Maine Lawyers for the Rule of Law presents Standing Up for the Rule of Law. How do we save it? Learn more or donate to the cause at mainruleoflaw.org.
Good evening. My name is Bill Harwood, and on behalf of the Maine Lawyers for the Rule of Law, it's my great pleasure to welcome you all here to our public forum on the rule of law. Over the last few months, the rule of law has suddenly become a big part of our national discussion. Many of us struggle to fully comprehend and explain the term. But tonight, we hope that all of you, when you leave, have a clearer understanding of why this principle is so critical to the future of our democracy. To get us started, we're so pleased that Governor Mills could be with us tonight to provide a brief opening statement. After her remarks, my colleague Peter Murray will introduce our featured speaker, Harvard professor Noah Feldman. And then David Webert will lead a question and answer discussion with Professor Feldman and a distinguished panel of our Attorney General Aaron Fry, the ACLU Legal Director Carol Garvin, and the State Bar Association President Susan Fonce. Following initial remarks from each of the panelists, we invite you, our audience, to ask questions of Professor Feldman and the panel. After all, this is a public forum, and your participation is important. So, we start with Governor Mills. Fortunately, she's no stranger to the rule of law. Through her long and distinguished career of public service, she has consistently worked to preserve and uphold the rule of law. For 14 years as district attorney, Janet Mills made sure that those who violated the law, regardless of wealth, privilege, or political affiliation, were held accountable. That's upholding the rule of law. For 6 years as a state legislator, Janet Mills shaped legislation that addressed the needs of all Mainers, not just those of big corporations with well-paid lobbyists. That too is upholding the rule of law. For 8 years as Attorney General, Janet Mills made sure that those who violated our laws protecting workers, consumers, and the environment were held responsible. She was also not afraid to stand up to our governor when he didn't follow the law. That too is upholding the rule of law. And finally, for the past 7 years as our governor, Janet Mills has not been afraid to stand up to those who believe they are above the law. Her rallying cry, "I'll see you in court," Her rallying cry, "I'll see you in court," inspired so many of us and gives us all hope that ultimately the rule of law will prevail. And yes, making that statement is upholding the rule of law. Please join me in giving our governor a warm welcome, Governor Janet Mills.
Thank you so much. Thank you. Thank you. Thank you, Bill. That was a lovely introduction, just as my mother wrote it. So, Lawyers for the Rule of Law. Actually, that should be considered a redundancy, shouldn't it? Aren't we all for the rule of law? I mean, come on. I'm proud to bear Maine Bar number 1677. You can take that to court. I took an oath, like many of you did, to uphold the Constitution of the United States and the Constitution of the state of Maine. Embodied in that sacred document, the United States Constitution, is the idea that the country is not governed by a king or by any single individual, but by that great equalizer, the rule of law. A few decades ago, some of you remember, that principle was in great danger. Our nation watched as the moral compass of the law was diverted from its North Star by the pranks and practices, the crimes and cover-ups of those who valued political loyalty over their duty to the courts and their duty to the Constitution. The President of the United States, for the first time in history, was forced to resign. Prominent lawyers lost their license to practice law, their livelihood, and the Attorney General of the United States went to prison, all because of the national scandal that we refer to very simply today as Watergate. It's a piece of history that seems so long ago, but that carries some currency today. Lawyers and law firms are again under tremendous pressure to bow to the demands and financial threats from political powers in D.C. Earlier this year, acting U.S. Attorney in the Southern District of New York, Republican Daniel Sassoon, stood up for the rule of law when she resigned her position instead of bending to the Trump administration's demand that she dismiss serious criminal charges against the sitting mayor of New York City, Eric Adams. Ms. Sassoon said that resigning to her didn't feel brave. Rather, she had simply honored her duties as a prosecutor by serving the public without regard for the political or personal implications, end quote. In line with its attack on the rule of law, the current administration also issued executive orders to various law firms by name. Those executive orders suspended security clearances for employees of the firms, barred access to government buildings and contact with government officials. Hello, what happened to the right to petition our government? And terminated government contracts with those firms by name. Those executive orders generally began by accusing the firms of, quote, dishonest and dangerous activity, end quote, all because they once represented clients with whom the current president disagreed. The orders often declared that those firms' practices of hiring women and hiring minorities created a security threat, quote unquote. 9 law firms swiftly cut deals with the president to be spared these acts of retaliation, agreeing to perform nearly $1 billion in pro bono legal work for causes he championed and he chose. That includes firms whose lawyers are now working with the Commerce Department to negotiate tariffs and financial deals on behalf of this administration to acquire equity in private U.S. companies like Intel. Well, that's a far cry from what you and I would call pro bono. Meanwhile, 4 firms did stand up, and they chose to fight the administration's executive orders, and they have won decisive victories in the courts. Federal judges who were appointed by Republicans and Democrats, presidents alike, have struck down the president's orders as a violation of the firm's First and Fifth Amendment rights and as an assault on the American legal system. And the administration continues to attack the court itself when it fails to get its way. When they lose in court, they use name-calling dangerously and accuse sitting judges of hating America and of suffering from a, quote, sick ideology. Look, I've lost a few cases. I've won a lot, but I've lost a few cases in court. I would never turn on the sitting judge and tell the people that that judge hates America. Come on. And in April, though, in a case involving a deportation matter and due process rights, a Reagan appointee, Fourth Circuit Appellate Judge J. Harvey Wilkinson III, described the assault on the legal system with some very eloquent but disturbing words. He said, quote, "Now the branches come too close to grinding irrevocably against one another in a conflict that promises to diminish both. He said, "The executive may succeed for a time in weakening the courts, but over time, history will script the tragic gap between what was and all that might have been. And law in time will sign its epitaph." End quote. Some law firms, some lawyers are helping write that epitaph. But others, like Danielle Sassoon, have shown courage in speaking truth to power. Like many Maine lawyers, I was raised to stand up to bullies. My father told me, "You can't let bullies have their way. They never stop." And so when the President of the United States unexpectedly confronted me at the White House earlier this year, when he threatened to cut off all federal funds for our small state unless I agreed with him, I responded as simply as I could, like any country lawyer would. "I'm complying with state and federal laws." When he declared, "We are the federal law," I said the only thing that I knew to say, and what I believe any Maine lawyer would say in my place: "See you in court." I didn't think anybody heard that. But apparently it's spread because people are sending me hats and t-shirts now. Anyway. But look, the president's demand, the impermissible threat in his words, the attempt to govern by intimidation, that's not what the founders meant when they wrote the Constitution. It is, in fact, the very thing they most feared when they divided power among three co-equal branches of government. And as every one of you knows, the chief executive may not create a law, amend a law, repeal a law by tweet, by executive order, by press release. The job of the chief executive is simply to take care that the laws be faithfully executed. It's Congress that makes the laws. Well, since that February day, there have been so many other threats across the country, more bullying towards businesses and firms and colleges and scientists and researchers, towards unions, veterans, women, threats to Social Security, threats to health care, threats to medical research and education, threats towards states and countries, large and small, threats to the judiciary, imperiling the safety of individual judges, threats towards highly decorated members of the military whose patriotism is unquestioned. But we know, you and I, that the law is neither red nor blue. It is not owned by any political party. It is not the tool of the chief executive. The law, very simply, is the greatest achievement of our society. It is the thing that protects all of us, but especially the weak and the vulnerable, those who cannot stand up for themselves. And if we stop believing in that great equalizer, the Constitution, if we give up, if we lose faith, then we lose the very thing that protects every one of us at a time when we need it most. Now, more than ever before, this country needs capable lawyers with morals and conviction. People who do true pro bono work, people who take tough cases upholding the free speech of protesters and others with whom they may disagree. People representing causes large and small in state and federal courts with or without fanfare or compensation. People who will protect the habeas corpus rights of those fleeing persecution and seeking freedom in this country, but now facing deportation. This cause is both grassroots and top roots. For the rule of law must blossom at every level, in every court, in every town hall, in every place where rights are questioned, where a door is slammed, where people are left out and others let in because of political connection or wealth. We have to be vigilant to preserve the Constitution of the United States and of this state. I hope you will all act before history scripts the tragic gap between what was and all that might have been. I know that you all will stand up for the rule of law. And whenever and however you do stand up, believe me, you will count for more than you think. Our country will stand taller. Our country will be stronger. The rule of law will thrive. I thank you, and I'll see you in court.
Thank you, Governor Mills, for your informative and inspiring introduction to tonight's public forum on standing up for the rule of law. It's my pleasure to introduce our keynote speaker, Professor Noah Feldman. Professor Feldman is uniquely qualified by intellect and experience to talk with us about the meaning of the rule of law and how we, as lawyers and citizens alike, can stand up for the rule of law in these trying times. Professor Noah Feldman is the Felix Frankfurter Professor of Law and Chair of the Society of Fellows at Harvard University. He's one of our nation's leading authorities on the history and meaning of our Constitution. He's the author of 10 books and innumerable published articles, talks, and podcasts on constitutional law and related topics. In the real world, he served as advisor to the Iraqi Governing Council on the creation of Iraq's interim constitution. In 2019, he was one of the law professors who testified before the House Judiciary Committee regarding the constitutional grounds for presidential impeachment in connection with the impeachment inquiry against then-President Donald Trump. Particularly important for tonight's public forum is our speaker's demonstrated ability to discuss constitutional concepts with non-legal groups and audiences. For years, he has served as policy and public affairs columnist for Bloomberg Opinion. He's also written for the New York Times and the New York Review of Books. In 2020, Harvard Magazine wrote, quote, "Feldman is increasingly prominent as a public intellectual and a voice about public affairs. His work displays the mixture of synthesis and substantive mastery that serious journalists aspire to, and the combination of clarity and eloquence that few scholars display. He writes with the conviction that the most important public position in American life is that of a citizen, which makes his fellow citizens the most important audience for his writing about American public affairs." It would be easy for me to take several more of our precious minutes this evening to acquaint you with other dimensions of our speaker's expertise and experience. Instead, allow me to present Professor Noah Feldman, and he can speak for himself.
Good evening. There are a lot of lawyers in the room, I'm pretty sure. That means there are a lot of people who are accustomed to public speaking. So I'm going to ask you whether you ever had a dream like this. You were invited by a distinguished group of lawyers and public servants in a state you care a lot about to come and speak to a group of people who really care about the rule of law. And you get excited and you prepare your speech. And then they tell you, oh, by the way, right before you speak, the governor of the state will be giving her version of the rule of law. We know the audience elected her. We know the audience will be very probable in supporting her for her future elective endeavors. You'll be fine, don't worry about it. Welcome to my life. So with apologies in advance for any possibility of anticlimax, with your permission, what I'd like to do is just talk in the time we have about a few key facts. One, what exactly is the rule of law? I mean, if you're here tonight, you're already in favor of it, but it's useful to know what you're in favor of, I find. I mean, sometimes maybe better to keep your mouth shut, but in this instance, maybe good to know what it is. Second, where does it come from? Third, why is it good? And I will give you both a principled reason why it's good and a very bottom line, pragmatic things that you get out of it account of why it's good. I'll say just a brief word about why we need to talk about it now. The governor already did an incredible job of covering that, among many other things. And then last, but very much not least, I want to try to provide some actionable intelligence for everyone in the room of what you can actually directly do to help preserve the rule of law. And with any luck, that'll grow out of what I'm trying to say about what the rule of law is and why it's good. Okay, so that's the game plan, and I will try to do it succinctly. The rule of law is a framework on the books, and it's an actual way of life that's instantiated by a group of people, a community of people, in a particular place. So start with the framework part, which is in a way simpler, though it's kind of fascinating. The framework is the idea that in a given government, a given community, because all governments are intentional communities of people who've gotten together to decide how to govern themselves. So within a given government, we've agreed on a framework of rules, which we call laws, that we're going to apply to everybody equally. So there's a component that's about system. There's got to be a system of laws out there. There's an individual component. If you have an encounter with the government, or if you have an encounter with another citizen or another person on a legally related matter, then you individually and they individually are entitled to the law being applied to you. And finally, it's got an equality component. Everyone is going to be treated the same under this rule of law principle. That's why on the US Supreme Court in Washington, D.C. at #1 First Street, it says equal justice under law. That phrase, which interestingly doesn't appear in the Constitution, was chosen to go there because the job of the Supreme Court is more than any other job. It has other jobs too, but its most important job is to make sure the rule of law is followed. Okay, so that's the framework nature of the rule of law, and in a second I'll talk about alternatives. The part of the rule of law that is a way of life is a component that is much less frequently observed. There are lots of countries in the world that if you read their constitutions have the rule of law. And judges from those countries come through Harvard Law School practically every week. People come from all over the world. And the judges are coming kind of for the pleasure of being in a place where everyone agrees with them that the rule of law is important. Because a lot of them are from countries where the rule of law is just not that important or is ignored. And if they're judges, and they're the good kind of judges, they're trying to stand up for the rule of law, and they're not always winning. I mean, I would love to tell you they're always winning. The rule of law is on the march globally. No, the rule of law has its moments globally, and a lot of people think it's a desirable idea, but actually putting it into effect is way harder than just having rules. You need a whole culture of people to come to expect that when they encounter the government or when they're in court or in some other framework of context where they're dealing with their neighbors, that the rule of law will actually be followed, and they have to do something when it isn't followed. They have to give their assent to the system, and they have to withhold their assent from the system when it's actually not working. Now, we are so fortunate in this country. I mean, almost unimaginably fortunate that it's been already in historical time since the early 1970s, which the governor referred to, the Watergate scandal, when we had a big, public, uncontroversial moment when we said the rule of law is not working. Because we had a president who broke the law and who, when confronted with the evidence of breaking the law, said, okay, I'll resign. He didn't say it right away. He didn't want to say it. He actually didn't hand over all of the tapes that the Supreme Court said he had to hand over. But in the end, he did acknowledge his failings by stepping down. He was pardoned within 30 seconds. Okay, let's be clear. I don't want to overstate it, but it's more than a generation ago. It's in historical terms, 52 years, more than a half a century, since these things took place. And the privilege that we have, and it's an extraordinary one and a great one, and I'm grateful for it every day in my line of work, is that until now, we haven't had to stand up and defend the rule of law. Because everyone in our relevant community, within our way of life, just took it for granted. That was true of Republicans, that was true of Democrats, that was true of independents. That was true across the board. And anyone who arose who said, I want to use force or violence or non-legal means to change the way things are around here, was definitionally seen as an extremist, whether they came from the left or the right or someplace so wacky that you can't map it. Right? That is privilege of knowing that we're all in agreement about something. So that is the challenge that we're facing, and it's why, as I'll say in a little bit, we're going to have to think about these problems now more clearly, and also why it's hard for us. Because a lot of what I'm going to suggest that we do, you're going to say, well, yeah, we know that, but it's kind of hard to do. And there's a reason that it's hard. The reason that it's hard is that the rule of law is not just rules, it's a way of life, and we're used to the way of life, and we are unprepared for the challenge. I want to be clear. I'm not saying, oh, we're soft. It's good to be soft where the rule of law is concerned. It means the rule of law is working. So it's good. But now we're going to have to toughen up in some practical ways. Okay. Now, I said that you don't have to have the rule of law. And to use a concrete example of how you don't have to, consider the government that's done more to bring hundreds of millions of people out of poverty in the last 30 years than any other government in the world, and that's the government of China. To be more precise, it's the Communist Party of China, which de facto is the government of China. Now, communism is not in favor of the rule of law. Communism formally rejects the rule of law. You know, if you really want to know the reason, it's that Marx, the dominant theorist for all forms of communism, thought that the rule of law was a swindle. It was a swindle so that one social class, bourgeois people who possessed basic property, would get what they wanted. And in consequence, the Chinese Communist Party doesn't have any commitment to the rule of law. It also thinks it's a swindle. Now, as they've gotten bigger and more economically complicated, it's beneficial to them to have courts, and it's beneficial for them to have rules, but they don't have rule of law. They have something emerging that the scholars call rule by law. The difference between rule of law and rule by law is that the rules are on the books in both cases, but in a rule of law system, it doesn't matter who you are, the rules apply to you. And the people whose job it is to apply the rules take it as their sworn duty. They have taken an oath to promise, and they take it seriously as part of their way of life to do this, to treat every person who comes before them the same way. In rule by law, you call your party's superiors, and they call their party's superiors until you find someone who says, okay, we know what we're doing, and they tell you how to apply the rules. Xi Jinping did an enormous amount to reduce corruption in China by prosecuting, if that's the term, senior members of the Communist Party who were corrupt. The rules said you couldn't be corrupt. So that might sound like it's rule of law, but it wasn't. It was rule by law because he picked the people who he didn't like to enforce the law against. By the way, it still worked for everybody. Even the people he liked said, oh, maybe my corruption should maybe be changed now. The rule by law system will scare the living daylights out of you. It's supposed to. But the key point is it's a personalized system. It starts with one person at the top, and it applies to you individually, not as just a citizen like everybody else, but as an individual person who is either on the right side of authority or the wrong side of authority. Okay? That is rule by law. And I'm using the example of China not to be a big China hawk in this particular conversation, but for a specific reason. I want you to see that for many people in the world, rule of law is not that big a deal. And if you look at countries around the world that are asking, should we do more of the American democratic system, or should we be more looking into a Chinese system? I have bad news for you. As someone who, as you heard, cut my teeth helping to develop an Iraqi constitution, later worked on the Tunisian constitution, you need to have either an invasion or revolution to get people to work on their constitutions, which is a separate problem. But the reality is, right now, when those things happened, no one in Iraq thought, oh, we don't want a democratic constitution. Nobody. Nobody. Nobody in Tunisia after the Arab Spring thought, oh, let's adopt a Chinese Communist Party structure, the People's Standing Committee. No one thought that. Everyone's instinctive reaction was, I wasn't free, now I'm free. I want to have a better economy. I want to live well. I want the rule of law. I want democracy. 15 years later, that's less obvious to a lot of people around the world. That's why when we come to the rule of law and why, which I'll do in just a second, I'm going to emphasize that there are moral reasons to want to support the rule of law in addition to practical, pragmatic reasons. Because there are plenty of practical reasons to not want the rule of law. Now, the last thing I want to say before I dive into that is I just want to give the other side its due, explain why some people think the rule of law is a mug's game. And I don't think this is a crazy view. I think it's wrong, but I do not think it's crazy. So the idea begins, and it's a very old idea. If you have to name someone and make them responsible for it, you could blame Plato. He's dead. He's not going to object. Who think that all forms of government come down to a person. Could be a really good person. Plato said it was a philosopher king who always makes the right decision every time. It could be a terrible person. It could be a tyrant. And so your fate is going to depend on whether you're lucky enough to be ruled by someone who's wise and good, or whether you're unlucky enough to be ruled by someone who's terrible. But the core insight here is that all acts of telling people what to do should be personalized. Why? Because everyone's different. The world is complicated. You want to get stuff done? You should pick and choose what you think the right outcome is, and rules don't let you do that. The rules say the case has to come out this way. And you see this in the writings of judges, no matter what their ideological preferences, all the time. A good judge will always have a lot of opinions where she says, my instincts are here, the equities are here, but the law is here, the law wins. That's not a trivial thing to say. The judge is admitting that it's the wrong outcome. But it's the right outcome because the system of law requires it. The standard view that is the critique of the rule of law says, that is so dumb. If you're the judge and you have the power, why would you ever say, so-and-so should win as a matter of morality, but the other side wins? No, it doesn't make any sense. That's the critique. That's a real critique, folks. And it's alive and it's well. You don't have to think that the President of the United States is a philosopher king, and I'm not even sure that he thinks that, although maybe on some days. You don't have to think that the other system isn't ideal, because no one thinks that Xi Jinping is a philosopher king. But a lot of people in China seem to be more or less okay with the way that he's doing it, provided he's continuing to grow the economy. The rule of law, in contrast, is a very radical idea. We're so used to it that we say it and we all nod and agree. Because it's our way of life. But it's a very radical way of life. And it was implemented by a very radical group of people who had fled the old country and Europe to come here to North America, to the area in which we now live, covered roughly by what is today the First Judicial Circuit, so that's Maine, New Hampshire, Massachusetts, and Rhode Island, Also, Puerto Rico was in the First Circuit, but that's not where they started. That was a different group of people from Europe. And in that area, that New England area, the Europeans who came and in some complicated and in our terms clearly unjust way interacted with and displaced the people who actually lived here, those folks were radicals. And they were radically committed to a version of Puritan Protestant Christianity that entailed the rejection of the papacy. And alongside their rejection of Catholicism and the papacy, and they were not rational on the subject, was the idea that every believer was the same in the eyes of God, and therefore that the same rules that they believed you could find in the Bible, and they took biblical laws, just to make sure you understand how radical they were. These were not proto-secularists. They took laws from Deuteronomy and they put them in the statute book of the Massachusetts General Court, which also included Maine at the time. Okay, that's how radical they were. These are not people who you and I would be like, oh, look at that great liberal. No. But core to their radicalism was the following idea. And that idea is that because we cannot rely on there ever being a philosopher king, because that's a great idea in theory, and no one's ever really seen one in practice for more than a few minutes, we can't run government that way, because to be too personalized is to invite injustice and to undermine the idea of equality. So if you believe in the rule of law, what you're believing in is the idea that the system of rules should apply impersonally to you, even when it's going to produce a bad outcome in the particular instance, because overall it's going to do better. That is a radical idea, and it's not necessarily right. I believe in it. I hope many of you believe in it. I hope I haven't undermined it too much by presenting the counter-argument, but that's an occupational hazard if you're a law professor. I believe in ideas for grown-ups. It's never worth believing something unless you know the counter-argument. So I gave you the counter-argument. This is a radical idea, and it's based on the idea that the rule of law system will work well most of the time, and when it doesn't work well, we'll pay that price in exchange for the certainty that we are being treated equally, that we are being treated fairly, and that if the rule is bad, if the law is bad, we can advocate for changing the law. That's it. That's the theory of the rule of law, and John Adams put it in the Massachusetts Constitution of 1783, which was also the Constitution of Maine as of 1783, that we may be, it introduced the separation of powers, just as the governor mentioned, and then it concludes that we may be a government of laws and not of men. Those go together. Of laws, yay, Aristotle, rule of law, Puritans, and not of men. Boo, Plato, Xi Jinping. That's the formulation. Like, those are the two possible forms of government we're talking about. Okay, so that's the rule of law. Why do we have it? I've already hinted at part of this answer, but I want to start with the moral reason we have it. The moral reason we have it is our belief, and it is a belief based on faith that cannot fully be supported by empirical data, that human beings who are fallible deserve to be treated equally by the institutions that they encounter, even when sometimes they would individually benefit by a little more careful analysis of what's fair to them individually. More radicalism. More radicalism. This is not the idea of equity, which is the idea that the way to do justice is to look at any given person and say, well, what do they need to, get along in the world? And then give them that thing. This is the idea of equality, which is the more radical idea that we want to be encountered under conditions that make us the same as everybody else, even when we're not exactly the same as everybody else, because we're not. We're human beings. We vary. That's the moral commitment. What's so great about that moral commitment? I know that the government is not going to pick and choose its friends. I know that when the government's going to provide a benefit to everybody, it's going to give it to everybody. I know that when the government is going to challenge me or charge me with a crime for violating the law, it's going to do that for everybody, and it's not going to say, we don't like Feldman, let's prosecute Feldman. That's a moral principle. It's a moral principle that says, the big bad government's dealing with me, I want to be treated the same as everybody else. I'll give up the favoritism that I might get when I voted for the guy who got elected, or when we're friends. I'll give that up, because there's a moral principle that says it's wrong to treat me differently under those conditions. Now, that's the moral reason for the rule of law, and that's not enough for everybody. Because we're human beings, and morality is great, but it tastes a lot better when you can wash it down with self-interest. There's a self-interested argument for the rule of law too, and it's really simple. You're not always going to be in charge. Whoever you are, no matter how successful you are, no matter how rich you are, no matter how well-connected you are, no matter how many years you've been first selectman in our town, one or two people like me live in a place with a town form of government, you are not always going to be in charge. Someone else is going to be in charge, and it's usually someone who ran against you and beat you that time. In a system that is based on the rule of law, you're promising that when your side has power, you will treat everybody the same, including the people you really can't stand, who don't deserve to be treated well. And you're trading that for the fact that when you're not in power, you too will be treated equally and personally under the rules. That's the pragmatic reason. So if you said to me, listen, Feldman, I live in a place where actually my we've kind of been in charge for the last 300 years. Tell me what's so great about this. I'm like, oh, I got a great moral argument for you. Because that person's not going to be convinced by this self-interest argument. Right? The self-interest argument only works in a place where we trade sides. We have a Republican governor, a Democratic governor, a Republican governor, or any other office. And that's still true in much of the United States. And in historical terms, it's true everywhere in the United States. I'm not going to talk about gerrymandering and the efforts to undermine that. We can talk about that in the Q&A if you want to. But for our purposes, I can just say we all live in a political community where power trades places. And in those places, you need the rule of law to be safe. So that you don't have to say, as I've had friends say to me, I'm worried about what's happening. Should I try to buy myself Portuguese citizenship? Personally, there is nothing that can get my goat faster than that, and I get very mad and I get very upset. Nothing against Portugal, they just happen to sell citizenship. Oh wait, maybe we do too. But to me, that attitude is the kind of attitude that doesn't lead to upholding the rule of law or to the success of democracy. That's the attitude of, well, if I don't like the way you're playing the game, I'll take my ball and I'll go home, or I'll go to Portugal, which is not my home. In that system, no one's invested in what's coming next. You have to believe you're going to live here, and your kids are going to live here, and your grandchildren are going to live here, and your great-grandchildren are going to live here, at least here in the United States. And so you have a long-run incentive to produce that self-interested system. Right now, we're in a place where a lot of people in the United States, and I truly am saying this independent of partisanship, where a lot of people in the United States seem like they've forgotten, and this is really true on both sides, that we trade off who's in charge in this country. There's a lot of areas where this comes up. Free speech is another great one, but that's also for the Q&A. Okay, so those are my moral and my pragmatic arguments for the rule of law. I said I would say only very briefly why we need to focus on the rule of law. I'm going to use a statistic. I'm with Mark Twain. There are lies, damn lies, and statistics. But I'm going to use a statistic. It's not perfectly representative, but it speaks to us here in the area that I call the First Circuit. In the First Circuit, since January, there have been 72 lawsuits filed against the Trump administration alleging some violation of legal principles by some executive action. You have to trust me that that's a very high number. The courts have issued at least preliminary judgments in 52 of those cases. Of those, according to analysis that Reuters did, and I didn't get deep into the data. It was in the paper this morning, and I just said that'll be useful, so I took it. I haven't analyzed the data, so don't come back to me and say the data's off. Maybe it is, but Reuters is pretty reliable. 46 of those cases where there's been a decision, the judge has ruled that the Trump administration acted unlawfully, at least in part. 46 out of 52. Now, let me be clear. That's in the First Circuit, and the great majority of the district court judges in this circuit, for reasons that have to do with the way the Senate functions in the appointment of federal district judges, are Democratic presidential nominees. And that's also true on the First Circuit. I think it actually might be everyone who's active on the First Circuit at the moment, although that's going to change soon enough. So I'm not here to tell you that that's representative of the country, but it's still an incredible statistic because it shows you that what we're facing now is not normal. It's not even what happened in the first Trump administration. And as Peter told you, in the interest of honesty, I actually testified in front of 30 million people on television that the first President Trump in his first term of office had conducted some actions that I believed the framers would have believed deserved for him to be impeached and removed from the presidency. So it's not like I think that what was going on in the first Trump administration was just some walk in the park. Okay? I staked everything I had on that, on taking that position. But this is on a whole different scale. It's on a whole different scale. And I truly believe that even the supporters of President Trump agree that this is different, that it's on a different scale, and that Donald Trump is not committed to the rule of law, but is committed to something much more like personal rule. And I think a lot of those folks, not all, but a lot of folks who strongly support President Trump, think that that's fine given the world as it is. Okay? I'm not faulting them for holding that view, because as I said, there's a respectable intellectual tradition behind it, and you don't have to buy the self-interest argument, although rationally I think everyone should, but hey, this is the world, not everyone's rational. Maybe they think if they change the rules enough, they can stay in charge, and then maybe it wouldn't be rational to have the self-interest argument. But I think, and this is mostly based on my conversations with pro-Trump people, and this is not true of everybody. There is also a core of pro-Trump people who say the president is following the rule of law, but say that the derogation from the rule of law already began in the previous administration under President Biden. And I should just say, again, in the interest of fairness, they have Exhibit 1, and that exhibit is the criminal prosecution of Donald Trump by the Department of Justice. Okay? I mean, I really just want to say this as clearly as I can. Democrats cannot say, truthfully, the Trump administration started this. They can say, we think the prosecution of Donald Trump for the January 6th related events was totally justified, and we think that these other prosecutions the Trump administration is starting are unjustified. You could say that. It might even be true. But you can't say, oh, they started it. That's just not true. It was an epochal decision to criminally prosecute the past president of the United States. It had never been done before. Gerald Ford pardoned Richard Nixon. He didn't prosecute him. Okay? I mean, it maybe didn't occur to anybody, but one thing Joe Biden could have done was say, I think Donald Trump is guilty of crime after crime after crime. I pardon him. Would have been a good idea? Probably not. But it would have been a way of communicating a condemnation of criminal action without setting the country up for a prosecution that was blocked by the courts, that was ultimately, in a very complex way, blocked by the Supreme Court, and which sent the message to President Trump and his voters that the system was not business as usual. That after we beat you in an election, we then prosecute you. There's no way to prosecute the former president of the United States in a way that's totally impersonal. I hate to say it. I wish there were. The Biden administration tried everything they could. Merrick Garland, federal judge, one of the great public servants, one of the fairest people you could ever meet, one of the most impersonal people you could ever meet, actually, bent over backwards to create impersonal layers between himself and the president, between himself and the prosecutors and Jack Smith's team. They did everything they could do, but in the end, if you've been president of the United States, you're just too big for your prosecution to occur impersonally. So I just, I'm putting that out there because I really want to be clear that this is not, I'm not saying something that is fundamentally partisan, and I'm really not saying something that is where Democrats should be able to say to themselves, our hands are totally clean. This just started yesterday and we had nothing to do with it. That's just not the way the world works, and it's not how the way the world worked here. Okay, so given all of this, we are in a completely new environment where large numbers of Americans are expressing, let's call it, a healthy skepticism about the value of the rule of law. And that's why we need to talk about the rule of law, and that's why we need to talk about where it comes from and why it's valuable, because it's not obvious anymore, and here's the key point, because it's no longer a given that our way of life instantiates the rule of law. It's no longer a given. And once you lose that, it's very hard to get it back. I tried really hard in the car on the way here to see if I could think of a clean example of a country that had the rule of law, lost the rule of law, got back the rule of law. Like a perfect screenplay structure. I couldn't think of one. I'm not saying there aren't any. I was very excited to speak, very nervous about speaking after the governor. So, I had other things on my mind. Maybe there are examples. I don't want to say they don't exist. But none of them came to mind, and this is what I do for a living. So what's the actionable thing to do under these circumstances? And in a way, everything else that I said you can forget if you take away the to-dos that I want to offer you. They all derive from recognizing that the rule of law is a way of life, not just a system of rules. We have to address the problem at the way of life level, not only at the system of rules level. So the system of rules level is straightforward. You see institutions like the presidency disrespecting the rule of law. You begin by saying, that is not the law. And you don't just say it, you back it up by showing you believe in that by going to court. My home institution, Harvard University, got a letter sort of like the ones that went to the law firms, but way worse, because it cut off most of the funding for the university, which, to be clear, is not funding that's like, the word grant is a problem in this context. It sounds like you didn't do anything and they just granted you the money. A grant, in academic terms, is a competitive prize that you get when you apply in conflict with all of the other greatest people in the world at a thing, and you win to do your research. That's what a real research grant is. It's a competitive process. So it was a real threat, and my university went to court. And so far has won in court. That is scary. That is a high risk. And there are plenty of people who think the university should still settle. So I just want to be clear, that's because it is high risk, and reasonable people could say, this is very high risk. Aren't you better off making a personal deal? If you really want to stand up for the rule of law, you have to take the risk. That's on the framework side. You go to court, you make your case, you tell people that you're making your case, you tell people the law is on your side, you hire the best lawyers, and you hope that the judges do their job. On the downside, if they don't, you can criticize them for not doing their job. That's the systemic part. It's pretty straightforward, and it's very important, and it's very high risk. But if you're the person who's under threat, it's also straightforward. And once you've done it, you're standing there saying, like, now what? And if you're a bystander and you're not personally under threat, it's not so obvious what you're supposed to do. Here's where the way of life comes in. First, you must say to yourself first, to your friends and family second, to your community third, to your elected officials fourth, to the internet via social media if you must. And not everyone in the room is an old lawyer, and there are old lawyers who use the internet super well. So anyone here who has a social media account knows exactly what I'm talking about, and you don't have to be the poster. You can just comment. You can even just like. That is still an action. It is still an action. It is a small action, but it is a meaningful action because everybody who cares is checking the numbers. Everyone in the system at every moment is trying to figure out where the public is. I'm going to come back to the public in just a second. So by speaking out, what you're doing is you're saying, this is not normal. These are not the rules, and personal application of the rules is not our way of doing things here, and we don't like it. If you get a chance, you can give the moral argument. You can say, this is not treating me as an equal citizen. If you get a chance, you can make the pragmatic argument. You can say, this is a bad idea. It's going in a direction where when the other side comes to power, they're going to act personally, and they're not going to respect equality. So we don't want that. You can make that argument. Those are great arguments. You can make them as briefly as I just did. They land. But mostly, you have to talk. You cannot think, well, I went to the event, I did my part. And I'm literally preaching to the choir, literally, because you're here. Okay, I'm not trying to beat you up or make you feel guilty. I don't go in for that kind of sermonizing. You're already here, good. Take the point that we're all in agreement on and say it to everybody you know. Even if you've become that person in the family who won't shut up about it, that also has an impact because it shows that it matters to you. You're signaling that it matters. Okay? Why do these individual actions matter? Well, for one thing, they affect the process of voting. Now, voting is something that the historians are going to look at us in this period of history and be mystified by. And they're going to want to know why it was that the followers of Donald Trump in 2016 and in 2020 caught on to something that their opponents were not as clear on. Namely, that it really matters who you vote for. The parties are not the same. Their preferences are not always the same in every case. And the individual people within the parties are definitely not the same. Even though there, of course, are centrists. I mean, to be clear, I like living in a world where the parties are basically the same. That's great, because that means that lots of reasonable people are negotiating with each other. I'm betraying a preference for that. But it's not always true, and it's not true today. So the outcomes of voting matter vastly and in every consequential way that they can. And that's not just a principle thing. It's not like voting so you have a little sticker that says you voted. It's voting to preserve your way of life. And you have to communicate that urgency to everybody else. We are so safe on the whole in our country that even when there's a bad political outcome, it doesn't really motivate us, that we don't like, it doesn't really motivate us typically to get out and vote. But some people have noticed that if you get out and act, it makes a difference. And it feels inspiring. So that's one reason to do it. That's a crucial reason to do it. But the deeper reason to do it comes back to the idea that the rule of law is a way of life. The only way to fix the way of life when it's not going the way it's supposed to is the collective disapproval of everybody of the way we're deviating from our way of life. You have to be judgmental. You have to be very judgmental. You can't be relativistic about those topics. You have to say, it's true that there are rational reasons to not believe in the rule of law, but that's not how we do it around here. We got to be the country we are by respecting the rule of law. That is what we're about. That is what we should be about. And when someone says, well, you know, do you really believe that? The system was always rigged. You say, of course some systems get rigged at some points, and that's bad. We don't want that to happen. So that insistence, that collective judgment, is something that requires everybody. And it's why in a democracy, when we say that the people rule, we don't just mean that the predicted likely primary voters rule. We mean that everybody participates in rule, whether they vote or not, by virtue of their opinion, because that's what democracy ultimately rests on. You cannot have a successful democracy if people don't care. Or if they care and don't act, you will also fail. The system just can't work that way. And you could say, well, that's not that big a deal, so it won't work. And you're right. Maybe we'd still be fine on some dimension. But we wouldn't be the people that we wish to be. So in a sense, the privilege of having been able to go for so long without a challenge to the rule of law has put us in a state where we're not used to getting exercised over threats to the rule of law, and now we need to get exercised. And I don't care how trivial the context is where you get exercised, it matters. And it matters a lot. It matters a lot. So I'm going to close here because I don't think I have a better call to action than telling you that the fate of our society as a rule of law democracy is going to generationally be determined over the next 4 years. We're going to go one way or the other way. It's not going to happen all in one big go, but it's going to be a sustained, very loud, in your ears drumbeat that's not going to stop, certainly for the next 3 years and however many months it is. It's not going to stop, and it's not going to go away because the structures are in place for real, meaningful change. We're going to know the outcome. It's not going to be uncertain. We're going to know the outcome. We're going to feel the outcome on a day in and a day out basis. And it is actually within your power, with your friends, with your families, with your communities, even with that amorphous thing, your social media account, to participate actively in preserving the kind of society you want to live in. So do it. And do it for the right moral reasons if you can. We all want to be treated the same. Do it for the right pragmatic reasons if you prefer. Do it so that when you're in power and then someone else is in power and then someone else is in power, everyone's safe. But by all means, motivate the people around you to do it. And if we do, it can still come out the right way. It is not over. It is not close to over. Most people that you know and most people in the country still believe firmly that the rule of law is our way of life. So let's make it our way of life. Thanks.
Up next, our expert panel discussion. Please consider donating to the cause at mainruleoflaw.org.
Well, wow, that was an amazing 1-2 punch we had there. Harvard law professors are always smart. We knew that. But I think that speech made us all feel smart and empowered, and that's not the usual Harvard law professor. So we had a rare treat tonight. It was a
Thank you.
great privilege to hear that and very inspiring. My name is David Webert. I've been a civil rights lawyer for 40 years. My major qualification for being up here is that I have successfully sued Governor Mills and Governor LePage for violating the Constitution. So nobody likes me, and that's just fine. That's the life I chose. So I'm really looking forward to a lively discussion. I think this audience is going to have great questions, and I'm really looking forward to that. But first, we actually have 3 other stars in Maine that not only know the rule of law, but also have been on the front lines fighting for it this year. So it's really an amazing trio. And I'm going to start with, and each of them is going to speak for 5 minutes. And then we're going to open this up to questions and have a lively debate. And you can grill the professor and the lawyers. And the meter is not running, so enjoy yourselves. So our first speaker is Maine's Attorney General, Aaron Frey. He's been representing Maine in court and winning important cases this year to uphold the rule of law. You probably have been reading about it. A couple of examples are something called the power of the purse that most constitutions give to Congress. Our Constitution seems to give it to Congress, and he fought to make sure that funds could not be withheld from hungry children in Maine by the executive branch, And he and his office are amazing. They're lawyers that have been there for decades, and they are top-rate lawyers. And the judge in that case happened to be appointed by a Republican president, and he ruled for them almost instantly because they made such a powerful case that the president doesn't have the authority to withhold funds from Maine that Congress said should go to Maine for hungry children. And also that the president has to follow the law, including the requirements for due process before taking away funds from Maine. In addition to cases in Maine, Attorney General Frey has been joining with other state attorneys general in many successful court cases across the nation, including in Rhode Island and all kinds of places where the attorneys general have been working together in a very important way, one of the most successful law firms, shall we say, in the country, and really pushing back and getting a lot of victories in court throughout the country and saving a lot of states from losing out on key funds that were being withheld as part of extortion. Aaron Frey's been our Attorney General since 2019, and before that, he represented parts of Bangor and Orono for 3 terms in the Maine House of Representatives from 2012 to 2018. I'm going to turn it over to the Attorney General.
Good evening to you all, and let me just say I want to thank you for doing what Professor Feldman has said we should be doing, which is coming out and making sure that rule of law is important, because democracy is hard. You really have to want it, right? We've all heard that quote from the American president, right? You really have to want it. We have to work at that, and indeed, that is the task that is put before us at this point in time in our history, right? And so much like I'm sure you all feel, when I look at what's happening on the federal level, I think about the personal data that's being sucked up by Elon Musk in Doge and put in places that I'm not sure how it's going to be used. I see money that is being deprived from research and from individuals and from organizations who Congress said should get the money to do good things that we need done, but the president is just deciding without reason not to send it that way. The environment is being hurt. Students are being hurt. Individuals are being hurt. And the checks and balances that we have all depended upon to take action when one check or one balance is out of check or balance, we are not seeing come forward with the sort of energy that you would expect. Where is Congress, right? We've heard... So we've heard about the power of the purse. When we're talking about money that's being withheld, this is not discretionary funding, right? This is the kind of funding that goes to states that are Republican, that are Democrat, that are unenrolled, that's going out to do good things that Congress said needs to be done. The president just needs to make sure to follow his oath under the Constitution to enforce the law and send that money out. Why in the world are you holding it back? Congress, why are you not doing more to tell the president that he has to do his job as he swore to do? Where is Congress? The majority in Congress is not stepping up, right? And so what that has left is litigants have to go to another branch of government, a passive branch that requires activation, the judicial branch. Now, another check that isn't talked about as much up to this point, but is indeed a very real check that has strong foundation if you read the Federalist Papers, states are a check on the federal government, right? And so my colleagues and I'm sorry to say that it's been Democratic attorneys general, because as I mentioned earlier, this is not a party thing about who's being hurt. It is in some cases, I'll touch on that briefly. But this is Republican states not getting resources for their schools or for education. It's Republican and Democratic and unenrolled states where their labor force is being impacted because of the massive cuts to different federal institutions or grants that support labor. Environmental programs that are being cut at all across. You have Tim Cotton, a very Republican senator from down south, complaining that he's not getting FEMA money for his state, right? There is no political, there's actually nothing behind what the government's doing because there's no transparency about what Donald Trump is doing when he's withholding these funds. Which is why when Democratic attorneys general go to court, and we've gone about, not to throw more statistics in, but we're about 53 cases at this point that we've either brought on our own. Maine, for example, has 4 different cases that it's litigating just by itself related to the federal government, or joining with others. We are seeking to hold the federal government accountable under the rule of law, which is what they are committed to do by our Constitution when they took their oath. And so far, we have been successful at the federal district court level. We have been successful at the circuit court level. As it was mentioned, we have Democratic judges, we have Republicans, or appointed by Democrats, appointed by Republicans, who are all deciding that no, even the president has to follow the law. The Supreme Court is taking a little bit of time to catch up. And I guess I want to be careful with this because we don't see yet that they are going to completely adopt what the president has said is correct. But what we are losing is the ability to create a momentum that discourages the president to stop violating the law. Because what's happening is the Supreme Court is saying, well, we're not going to decide on the merits. We're going to issue these shadow docket opinions, these emergency docket opinions. We're not going to tell you what we're thinking, but we're going to chastise lower courts if they don't guess what it is that we're thinking. And we're going to lift injunctions that prevent the president from arguably violating the law while the case pens. So look, in Maine, for example, you've heard this, and I'm going to wrap up on this. We have had success when without any reference to a law, the USDA tried to withhold $3 million that feeds 172,000 school children, right? Republican, Democratic, unenrolled families, also feeds disabled adults. We have forgotten that there was somebody else who was impacted by that. We immediately went to court, and we almost immediately won because the administration didn't even think to crack open a law book when they just withheld the funding. And we won, and what we showed is that you don't have to do what the president says just because the president said it. And we created an example that if you stand up for that principle, if you're like Harvard, for example, or you're like those law firms that do stand up, or if you're like the universities that are actually standing up, that you will be able to hold even the President of the United States accountable. 2 other cases I want to point out. One that we just successfully got closed down. There was victims. If we did not agree to what the Department of Justice wanted us to provide for information so that they could do immigration work, this was handing over personal information, they would stop sending money to the state of Maine to take care of victims. We took that to court, and the administration immediately stopped the withholding of that money because they knew they got the law wrong. And then just finally, I want to point out that we've had a case in Rhode Island for a while. We started it very early, in which we confronted the President of the United States who was just freezing funds to go out. We have so far not only successfully gotten an injunction to keep the money flowing into the state, but when the federal government has not been doing a very good job at following those orders, we have been able to get the lower courts to compel the federal government to make sure that money goes out. It's an early case, but again, it's an example of where states are working together, one of the largest law firms, I suppose you might look at it as, to make sure that even the President of the United States is held accountable. I hope you will see that as an example of where if you say, no, the rule of law applies to everybody, and we're going to make sure our rights are recognized, you can have success, and we're going to keep fighting all the way through to hopefully make sure that the rule of law is not degraded to the extent that we're not going to be able to be rewarded once we get beyond this president.
Thank you, Mr. Attorney General. We also have the Maine State Bar Association President, Susan Fonts. She and the Bar Association have provided a strong Maine voice in support of the rule of law. On February 24th, which was pretty quick, the Maine State Bar issued a very strong statement which is not an easy thing to do. It has, board of directors from all over the state and is very nonpartisan, that many actions and orders that completely disregard the rules and processes essential to the rule of law and our constitutional democracy, criticizing public figures who make baseless accusations of corruption and call for impeachment of judges who do not rule in their favor when their actions are challenged in court, and who have vowed to ignore, if not openly defy, court rulings with which they disagree. And the Maine State Bar Association co-sponsored this public forum and our May 1 Law Day rally. Susan spoke eloquently at the May 1 rally, and she is one of the leading trial lawyers in Maine seeking justice for the innocent victims of serious personal injuries. Turn it over to Susan.
Good evening, everyone. For those of you who don't know what the Maine State Bar Association is, it's a voluntary association of approximately 2,600 lawyers throughout the state, and some attorneys who live out of the state but practice here in Maine. We're an organization that's going to be celebrating our 135th anniversary next year, so we've been around for a long time. And one of the missions of the Maine State Bar Association is to promote the fair and effective system of justice. And so that's why this association has stood up for the rule of law. I think lawyers are uniquely situated to be defenders of the rule of law based on our education and training, based on our training to be able to go to court and fight those tough and unpopular cases and novel cases. We are also, advocates of justice and, have experience speaking to the public and going out to the public to talk about these things. The rule of law is especially important to me personally. My mother is an immigrant. She was not a U.S. citizen. She came to this country. She specifically wanted me to be educated in the American education system because she believed that America was a land of opportunity, a place where I could be judged based on my own work and my own merit as opposed to my race or socioeconomic background. And she really just instilled those values in me, and that was predominantly the reason why I became a lawyer. Because I believe in democracy and I believe in the Constitution. I believe that we should all be treated equally. Those are values that our association is trying to promote, and one of the ways that we can do that is work with organizations like the Maine Lawyers for the Rule of Law. We have acted as a forum for getting information out there, and as David said, early in February, as I began my presidency, we issued a statement. In June, we also joined a statement with the ABA and a number of other associations across the state. We've participated in the Law Day rally. We have, at the Summer Bar Conference, had a panel discussion regarding the rule of law. And so we see ourselves as an organization that is able to disseminate information. We are also, we have a civics education branch, and we're hoping that maybe that will expand and that will help with getting out information about our system of justice and the three branches of government and how they work. So we're just excited about the rule of law. I'm really honored to be here today with these tremendous speakers. I'm kind of not sure why I'm here, but I'm here. But anyways, thank you for letting me have the opportunity tonight.
Thank you, Susan. We're lucky to have you here. The National Organization of Lawyers, because lawyers don't always get good publicity, I know, sued the Trump administration. That is not something that they do very lightly, over the extortion and attacks on the law firms. And so that is a good way of saying that's not okay. When the biggest organization of lawyers in the United States of America sues the government, that does not happen very often. So that is a thing you should know about. I'm not sure the press has talked about that much, but I think it's a really important thing to use when you're talking about why this is not right. And the third member of our panel is equally distinguished, the legal director for the ACLU of Maine, which is a premier constitutional rights and civil rights organization in Maine, Carol Garvin. She leads its lawsuits, tackling broad systemic issues through impact litigation, and just some huge victories. She and the ACLU have won emergency lawsuits in Maine that we've read about to stop federal agents from detaining Mainers in secret, incommunicado, with no due process. So we really appreciate that work, and that I know she had to do that like on the fly. She had 2 minutes to get things filed before the government was going to whisk people away to other countries or other states. So she was working around the clock. And she and the ACLU won a landmark class action case in New Hampshire to uphold the right of persons born in the United States to the full and equal protection of our laws. This is a very important case upholding the plain language of the birthright citizenship provision in the 14th Amendment to our Constitution, which is a key pillar of the rule of law. Hopefully the Supreme Court will catch up with Carol. Since it's in the plain language, and the Supreme Court has been saying it for over 100 years, I'm not sure what is taking so long. But anyway, Carol has also been a top lawyer in the lawsuit that we've all read about, holding Maine's government accountable for violating the fundamental constitutional right to legal counsel for folks who have been charged with crimes. I'm going to turn it over to Carol.
Thank you. It's so nice to be here with everyone this evening. So I think the rule of law is really a nebulous concept for a lot of it. We've got a lot more content from our speaker today, but I think it is one of those principles that is easy to say that you support in the abstract and then can be very hard to support when it comes to specifics. I think it's somewhat like the right to free speech, which again is an easy principle to say that you support in the abstract, and then can be harder to really fight for when you disagree with the speaker or the message. But in both of those cases, I think those hard cases, those are the cases where it is most important that we fight for those basic neutral principles, whether it's the right to free speech or the right to rule of law more broadly. The ACLU is a nonpartisan, nonprofit organization. We've existed for about 100 years. And in those many years, we've seen that attacks on the rule of law are not the monopoly of any one administration or party or person. We have seen violations and attacks on the rule of law that come from Republican and from Democratic administrations, from liberals and conservatives. We've seen attacks on the rule of law from the federal government, but also from state government and local government right in our backyards. We have also seen attacks on the rule of law that are willful, that are very obvious, but we see it as well in more examples of negligence, of just a failure to take the really hard affirmative steps that are necessary to preserve the rule of law day in and day out. And I think we see that in the cases that we are working on as an organization today. So I'll just briefly touch on kind of 3 categories of cases we're working on right now at the ACLU of Maine in order to work to defend the rule of law. So the first is the birthright citizenship set of cases, and that's really 2 entirely separate cases that we've brought with ACLU National and other organizations. So the day that President Trump took office, we filed our first birthright citizenship challenge, challenging the executive order that purports to limit birthright citizenship for certain people born, babies born to people of certain types of temporary or undocumented status. We fought to preserve the basic principle under the 14th Amendment that every baby born on US soil is a US citizen, full stop. We do not have second-class citizens in our country. We filed in New Hampshire. The federal court acted very quickly, actually issued a preliminary injunction from the bench, which I hadn't seen before, and struck down the executive order as a violation of the plain language of the 14th Amendment. That decision has then gone up to the First Circuit, and that was just affirmed very recently in a great opinion. So that's where we are in that case. Then at the same time, we have a second case, which is a class action birthright citizenship case. And so that case we brought the day that the Supreme Court issued its decision, which in other birthright citizenship cases said that district courts can't issue nationwide injunctions. So that left many hundreds of thousands of people without protection. And so we brought our case with a class of all babies born in the United States who could lose their citizenship under this executive order. And again, the federal court, same judge, acted very quickly, and this is a Republican appointee, but acted very quickly and both granted class action status and granted preliminary injunction against the executive order for that whole class. So that protects all of those babies. That case has gone to the First Circuit. We don't have an opinion there yet, but the government has already petitioned for review with the Supreme Court. And so we expect that it will be headed to the Supreme Court this term. In the second group of cases are immigration-related cases, and these are cases where we are seeing in Maine in the last few months that our federal immigration authorities have been taking people into custody and then holding them indefinitely in detention, often incommunicado, and not giving them any chance for petitioning for release on bond. We think that's a basic violation of their due process rights, not to have that process, that opportunity to seek release. And so we've brought a series of habeas cases, both individually and as part of a larger regional class action. And so far, courts are granting relief, and they are saying, yes, this is a violation of those individuals' due process rights, and they are ordering relief in the form of releasing them from the unlawful detention and also ordering that they need to have those bond hearings. That is the due process that they're due. We are also focusing not just on federal immigration authorities, but what's happening at the state and local levels. So we've been doing a series of public records requests through our Freedom of Information Act to try to better understand how are our state police, how are our local police cooperating with ICE and with Customs and Border Protection. And so we are getting more and more information every day about how that cooperation is happening, because we think this kind of transparency about what our government is doing is an essential part of protecting the rule of law. And lastly, I'll just briefly touch on the case that David mentioned, where we are working to preserve the basic right to counsel for all people accused of crimes who are at risk of jail in Maine. So the Supreme Court said many years ago, of all the rights that an accused person has, the most important is the right to counsel, because without it, they can't assert any of their other rights. We brought suit several years ago in Maine because we believe that that right to counsel is not being upheld. We are seeing hundreds of people who do not have counsel appointed, sometimes for many weeks or months at a time. And so we brought suit. The trial court issued orders in our favor earlier this year, and the case has now been appealed to the state Supreme Court. We just argued that last week, and so we are waiting for their decision. And so we're fighting for these protections, which I think in many ways really boil down to a basic right to due process at all levels, no matter who is threatening the rule of law and no matter what court those need to be litigated in. So really happy to be here today.
Not too bad. We have a half hour after all the lawyers are finished talking now to have, we usually go a little over, don't we? But we're doing great. So I'm just dying to get into the question and answer period. So I'm hoping people will start asking questions, and you can say who you want to direct it to or not, but we obviously have 4 experts here to answer your questions. Oh yeah. We could probably take turns going back and forth. So why don't you go first here?
Great. Thank you, Professor Feldman and Bill, for organizing this event. Great to see so many lawyers out here defending the rule of law. I guess I was taught in law school by you, Professor Feldman, back before you shipped up to Boston, to regard the work of the Supreme Court as essential in the role of defending the rule of law. And I feel like this conversation has sort of been haunted by both a change in the action of the administration, but also a change in the action by the Supreme Court. And it seems like any efforts to defend the rule of law will require some work to restore the legitimacy of the Supreme Court. Welcome, for those who feel comfortable, some commentary on the role of the current Supreme Court and sort of the path to restoration of that legitimacy in defense of the rule of law. Thank you.
Someone want to take a crack? I have something to say about it, but you guys want to jump in?
No, please.
First of all, nice to see you, and thank you. Yeah, it's the job of the Supreme Court as the highest court in the land to take account of the rule of law and to ensure that it's in play. I want to be really careful when I give my assessment of where the Supreme Court is right now over the last 9 months. There have not been that many cases that have come to the court in which the court has agreed to address the direct merits of whether the Trump administration is right or wrong in its actions. Now, you may say that's already a failure. They should have done more. And naturally, if I had been arguing any of those cases, or if I had the ear of the justices, I would tell them, I think you should be doing more. But I want to just be clear on why I think they are being cautious at this moment. I think they're being relatively cautious because they believe there is a genuine risk that the President of the United States might ignore a direct court order. And I think from that murmuring, everyone in the room thinks they're not crazy to be worried about that. Now, you have to remember that the Supreme Court, they wear two hats. One of the hats is, we just say what the law is, right? That's Chief Justice Roberts famously claiming that he's just an umpire. As a law professor, I'm not very convinced of the value of that analogy, but that's one of his hats. The other hat, though, is making sure that the Supreme Court, as the exemplar of the rule of law, still functions. And when Alexander Hamilton said in the Federalist Papers that the Supreme Court was the least dangerous branch, he didn't mean it ironically. Now it's ironic, but he didn't mean it ironically. He meant they don't have any troops to listen to them. They don't have any capacity to command Congress to do anything. They want to, if this is going to happen, first of all, they don't want it to happen. Second of all, if it's going to happen, they want to pick a case where if they issue an order, the lower executive officials will listen to them and not to the president. So they've been very self-consciously trying to pick and choose the cases where they'll weigh in the hopes of not getting themselves into a face-off that they think they might lose. They're signaling that they think they might lose. This year, and what I've just said is controversial, but we'll know whether it's true or not a year from now. Because in this next Supreme Court term, the one that's just starting up now, the court's going to have to take on a bunch of the issues that it's been ducking for the last year. And there's going to be issue after issue after issue. They're going to be about core issues of executive power. And last point here, and I just think this is really important. Saying that the Supreme Court must stand up for the rule of law is not saying that they should come out the way I want them to come out on every important case before them. There are cases here where reasonable lawyers could differ. They really are. I mean, the classic example is like the one facing Harvard. Executive branch just unilaterally cuts funding for something, and the Supreme Court hasn't come anywhere near touching whether that's lawful or not. They've just asked the question, in a limited set of circumstances, what court do you go to? The most boring question in the world to anyone who's not a lawyer. Either you have to go to the Court of Claims, where all you can do is get your money back after some lengthy process, and it's difficult or even impossible to bring a constitutional claim, or you can go to a regular federal district court. Now, that's a big deal, because it might be outcome determinative. But the view that you have to go to the Court of Claims to adjudicate your claim that the government owes you money that they haven't given you is not crazy. I think it's wrong, and I've written extensively about why I think that's wrong, but it's not crazy. And it's just crucial that when we say rule of law, it doesn't bleed into the rule of law is just what we think the law ought to be. So where the Supreme Court reaches legally reasoned decisions that I think are flat wrong, I don't think that's a failure of the rule of law.
So just to have a little revenge on a professor from Harvard Law School, right? We need to have a little, I'm going to push back on that a little bit just real quickly here, that 3 justices in the Supreme Court disagree and think what's happening at the Supreme Court is cataclysmic for our democracy. And the one that seems strange to me is the power of the purse. They can't figure out the power of the purse that is Congress's. And 3 times they have overruled lower courts who were saying, yeah, the power of the purse is Congress's. And Justice Elena Kagan, who's she was the dean of Harvard Law School.
She hired me.
She is the smartest and very, very thoughtful. She doesn't say it in its histrionic terms maybe, but she said, the majority's order has the effect of preventing the funds, these are $4 billion to go help very worthy causes abroad that Congress had appropriated to be spent, mandatorily spent, not just now, but because of their impending expiration on September 30 for all time. That sounds like a decision on the merits to me, and Justice Kagan. And then she says, that result conflicts with the separation of powers. That is from the most thoughtful person on the US Supreme Court that I can think of is saying we are in big trouble, and the Supreme Court is deciding on the merits in favor of Trump. So we just have a slight disagreement. But anyway, next question down there.
I mean, can I just say, I think Justice Kagan is correct in that opinion. What I'm saying is, every lawyer in the room, and also non-lawyers, you know the difference between an argument where I'm right and you're wrong, which is every argument, and an argument where I'm right and you're insane. But there's a difference. And all I'm saying is, even that case where I think Justice Kagan is flatly correct and the majority is wrong, it's not a case where the majority is making it up or there's no credible legal argument to be made on the other side. That's my view.
Yeah, but I think it's a decision on the merits because September 30 passed. So that's the thing I'm worried about. Anyway, this line up here.
What is to be done to resist the likely deployment of the National Guard and military troops in Portland and in Maine? What is to be done to resist the likely deployment of National Guard and military troops in Maine and Portland?
So I'll jump in. I mean, as we're all following right now, there has been National Guard that's been deployed in California, in Portland, Oregon, in Chicago, Illinois, in DC. DC is a little bit different because of the structure in which they have compared to states. California, Oregon, Illinois, DC, they are fighting the deployment. They're fighting the use of active National Guards in their states. Maine has joined in with other states to raise legal arguments about why this is an inappropriate use of the National Guard. And we are getting really good orders that confirm our understanding of what is and is not appropriate for the use of the National Guard. But as I sit here right now, without the full weighing in of the Supreme Court, right? And we don't have that yet. We are going to continue to be at risk for the use of National Guard until we have something final. Let me add something else that concerns me about this, because we talk about consent in what folks do and maybe don't respond to. I am concerned that the National Guard is only being used in Democratic states, big D Democratic states, or Democratic cities. And in some cases, you have Republican states who are willingly asking the president to let them send their troops, their National Guard troops, like Texas to Chicago, Illinois, send my troops up. If this doesn't give people the chills about how our armed forces may be used, I don't know what's going to shock people. So as it stands right now, Maine has not been on the list. We are not the Portland that's been targeted. But there is a coalition of at least Democratic attorneys general who are concerned about the way in which the president is trying to use the National Guard.
And on the other side, we all know Portland is a hellhole that's on fire, so it is justified. I'm just trying to be equal size.
So the answer I was looking for actually is that the Attorney General's office, the ACLU of Maine, Mr. Webert, and perhaps Mr. Feldman of counsel are already collaborating and preparing to resist the deployment of the National Guard and military troops to Maine.
Yeah, Democratic attorneys general are already actively resisting and making sure.
I wasn't talking about other Democratic. I was talking about you.
Yeah. So it hasn't happened yet.
And Ms. Govan and.
Right. We were preparing for this even before the election, right? We did not know what was going to happen in 2024 for who was going to win, right? We did not know what it was that we might have to prepare for January 20th, because we saw what happened on January 20th back in 2000, right? I'm sorry, January 6th of 2000. We saw what happened when there was a riot, frankly, a mob that tried to prevent Congress from doing its job. We've been thinking about this, but it hasn't happened in Maine yet. And if it does, as you've already heard the governor say, we'll see him in court.
I was also thinking Portland Corporation Council should be involved, basically because that's where I live and protest.
Professor Feldman, did you want to say
No.
Okay. Yes, please.
Yes, I was pretty stunned at the history of the rule of law that you introduced, Professor Feldman. It left out a lot of stuff. You know,
Can't believe I left anything out. God, it was so long as it was.
the lesson from Watergate for the modern Republican Party is not that they did a good thing. It's that they should have backed up Nixon and he would have never resigned. And that is probably the last 50 years of modern American politics. That lesson is why we're here. They learned it and they've never looked back. And that's why a junior level Reagan attorney is running our country effectively. John Roberts is basically, I mean, things like Shelby County, Citizens United, the student loan decision where a statute where Congress explicitly gives the president power to modify student loans is determined by the Supreme Court majority to somehow not mean the ability to modify student loans. And the idea that this is anything but rank partisanship is just law professor gobbledygook. And why are you,
Okay, thank you.
I want to be clear here. There is a question here. I saw a man be picked up by two federal agents a week ago on 47 Portland Street, an African-American man, and he was really calm, cool, and collected, and I was the one who was much more animated about what was going on. He was driven off and returned about a half an hour later because I was trying to figure out what they were going to do with his vehicle. That man is feeling the brunt of what's going on with the lack of rule of law that has been endemic in this country. I mean, J. Edgar Hoover, the Kavanaugh hearings where the FBI claims to do an investigation that is not an investigation of the actual, sexual harassment things that were actually on the table in that hearing for his nomination. I mean, what I would like you to ask your colleagues and yourself, because you've written many op-eds.
Well, you can ask me. I don't have to ask myself. You can just ask me.
Amy Coney Bryant is not going to be anything but a terrific institutionalist. And Brett Kavanaugh is not going to be anything but a great institutionalist. Wrong, wrong, wrong. You are backing up your friends in your careerist points of view.
Okay. Can we?
I mean,
let's go.
The question is, what are the law schools?
It's free speech.
Yeah, it's just a waste of
Going
time.
to do when the proverbial blah hits the fan?
May I respond?
Right?
May I respond?
Sure.
First of all, I share your outrage at the sight of people being grabbed up on the streets of our cities by people without uniforms who often do not present identification in unmarked cars. And I'm deeply, deeply, deeply concerned and focused in my own work on how we can frame legal arguments and public arguments about what's fundamentally wrong with that. So I want to align myself with your outrage on that point, and that's the most important thing you said. On the I'll just address the gobbledygook quickly, and even more briefly, I forget what it was, careerist cronyism. On the gobbledygook point, look, I see the interpretation of history that sees everything of the last 50 years, I don't know why you're stopping there with the Republican Party, as, Roy Conist evil. I see that. I can hear that view. As it happens, right now, the judges across the country, who in many cases are issuing responsible rule of law decisions, are Democratic appointees and Republican appointees chosen by Reagan, chosen by George H.W. Bush and George W. Bush, and in one remarkable case, involving the Portland, Oregon deployment, chosen by Donald Trump himself, okay? There are many, many legal conservatives who are deeply committed to what I call the Scalian trinity of judicial restraint, originalism, and the rule of law, and textualism, who are nevertheless, or through that, deeply committed to rule of law principles. Many, okay? We will see how the justices on the Supreme Court will vote on all of the relevant issues. And as it happens, Justice Barrett has emerged as the center figure on the court. She is the swing vote on this court. She's one of the most conservative people I have ever met in my entire life. And so the fact that she's the swing vote on this court is noteworthy. But she is the swing vote because she has repeatedly voted with the liberals and the Chief Justice on a number of cases, not in every case, to stand up for what I would consider rule of law principles. Does that mean that she's right all the time? No, she's wrong almost all the time about almost everything. That's always been my view, and it's what I've thought for 30 plus years. She knows I think that, and I've written it many times. But what I said about her was the truth, which is that notwithstanding her extremely conservative views, she is genuinely committed to the rule of law. And if we could choose between her and a true Trump loyalist, I will take her. And I believe that that statement, which I made, whatever it was, 5 or 6 years ago, has been fully borne out by her jurisprudence. So that's just a defense about that. And I promise you, there is not any way, shape, or form where any justice in the Supreme Court can help me in any way. So for what it's worth, there are many people I'd like favors from, but they are not among them.
Yeah, I think also attacking each other and our personal integrity is not helpful to democracy. That's what people that don't like democracy get us to do. So I would really try to resist that. And also, I think that is an undercovered story that there's so many judges appointed by Republicans that are eloquently calling out what the Trump administration is doing, and the press just drops it. But that is proof that this is not partisan. And these are some of the most conservative judges in the country saying, hey, this is, if you're conservative, you like the Constitution, right? And so they're very upset about it. And lastly, the rule of law is terrible. The rule of law is the worst thing ever, except for every other form of government. So it's not perfect, we know that, but it is much better than dictatorship or tyranny or et cetera. So yes, question.
Thanks to all of you for being here tonight and for your. So my name is Sue Roche. I'm the executive director of the Immigrant Legal Advocacy Project, and at ILAP we. Thank you. And so at ILAP, we've been seeing the, just dramatic impact on our immigration cases and the just really devastating impacts on Maine's immigrant communities that, as you've been talking about tonight, are just afraid of being swept up by masked ICE agents and, sucked into this detention and deportation regime that we are seeing, unfortunately, on a daily basis with our cases. And so I'm wondering if you can speak, I know you've already talked about some of the cases you've worked on and have talked a little bit about immigration, but if you can just talk a little bit about how specifically in the immigration context, these attacks on the rule of law are having an impact, and maybe sort of how that fits in with the administration's plan to move from rule of law to rule by law. Thanks.
I mean, I'll just say briefly, first of all, thank you for the work that you're doing. I think the public support for that is justified. The Trump administration has, on the whole, preferred to attack two classes: the very elite, Wall Street law firms where partners are making unimaginable amounts of money, and fancy institutions like Harvard University. That's one class, elite institutions that don't share their values. The second are the most vulnerable people amongst us, and those are people who are in many cases undocumented, and in other cases are lawful visa holders who nevertheless are vulnerable to being forced to leave the country. That neither of those is an accident. They're both manifestations of a kind of personal approach and style. The attack on free speech of lawful permanent residents has been particularly outrageous in my view. I teach free speech. Because it is black letter law going back to the 1940s that lawful permanent residents have free speech rights, and that means that a challenge to their free speech rights is a challenge to the free speech rights of every person in the room who's a US citizen. With respect to undocumented people, that's where your work and the work of others is so crucially important, because what the Trump administration has rather cleverly done is take a group of people without whom our economy couldn't function, but whom no one is prepared to stand up in the abstract and say, well, they are lawfully here, because technically speaking, that's not the case, or very few people are prepared to say that, and then to push the envelope of legality in a way that creates the conditions for stopping anyone in this room. That, I think, should be their downfall, and to my mind, the place for public focus, apart from the direct legal work that you do, is focusing on practices like unwarranted, what are effectively arrests of people with no identification. I think every single American understands intuitively that that is bad for everybody. And I want us to leverage that recognition to try to create protection that will extend in large part to this most vulnerable part of our population.
Any other?
Thanks, Stu, for being here. And we've obviously been working a lot together. I think what we see a lot with specifically the attacks on immigrant communities is sort of the clash of the way that the executive branch works versus the way that courts work. So executive action is fast and is not always as the way that the courts work is not always as quick. And so I think often we're seeing a very new, this has just happened multiple times in the last few months, new policy rolled out, new practice rolled out that has never been the way that the administration or the immigration administrative courts are doing things so swiftly that people who are trying to react and file things in court are sometimes not able to catch up. On the good side, I think, between immigration advocates and civil rights advocates and people all over the country working together, I think we are educating courts, and courts are really stepping up and rising to that challenge to act more quickly than I've ever seen. And we have courts in Maine and all over the country. I think Massachusetts now has something like 90 habeas that they've heard in the last couple weeks. It's unbelievable. And they are reacting at a speed and I think a comprehensiveness that we just don't usually see. So I think there is a bit of a mismatch of just how executive action works versus how courts usually work. But I think we are seeing courts rise to that challenge and just be able to act more quickly than we ever thought they would. So I think that's really a positive thing we are seeing.
Good news, we'll take good news. The federal courts underneath the Supreme Court get a very high grade. Yes?
Hello, hi. I am exercised. I am very exercised. You said, you've got to be exercised. I am exercised. I do every single thing I can do. I write letters to the editor. I rally. I call every day I call my elected officials. I'm a little person in we, the people of this country. And there are many, many people here that are the same boat. And we're very, very, very aware of all the things that we could talk about that has gone on in the last 9 or 10 months. And so I have several questions, but I want to be quick because others want to speak. One is, okay, we have the courts, and the courts have the lower courts have so far held a line. But then Trump will appeal, and the appeal goes on up to the Supreme Court. And then we have a shadow docket. The docket is insane, in my opinion. And so here's a court that has granted immunity to the President of the United States. This is a court that I used to look up to with great pride and see them come in at the State of Union address, and I'd be so proud. Right now, I am very, very, very discouraged. And they, to me, are a symbol of the rule of law. And in my mind, the rule of law is not even part of our lives, and it's very upsetting. My question is, what do we do? How do we, the basic people, how do we confront the federal government and maybe make our appeals to change some of these awful, awful decisions they're making? Can you imagine, ICE can just go and pick anyone up because they think they look like somebody, and that was approved by the Supreme Court.
Well, one quick thing is to vote. Because the Supreme Court, we can still vote.
But you can say that. But what about all the suppression and the voting that's going on? What about the gerrymandering? What about even this referendum that's coming up in Maine? That could get, if that doesn't.
Well, the other thing you can do is join any group that you believe in as a cause.
I do. But now the second, that's my one question is, what can we do to appeal to the Supreme Court to stop? It's so simple. Trump is not following the Constitution, so why don't they just come out with that and say that he is at fault? They don't. That's one thing. The second thing is, what about Trump's bogus law court appeals that come to the courts and they're not getting, he should be reprimanded or he should be, but they just say, the judges just say, oh, well, this is not much of a thing, but he should be counted.
I'm going to need you to ask a question and then so other people can
Yeah,
talk.
okay, well, that's what I mean. Well, can't there be some penalty to Trump for having all these bogus things in the court? I mean.
Okay. Anybody want to address?
Can I just say briefly, first of all, you're part of the solution, so thank you. Keep doing everything that you're doing. The Supreme Court has the composition that it has because of the democratic process and because the Republican Party put far more of its effort and objectives and motivation into choosing justices than the Democrats did over the course of 30 or 40 years. We Democrats, and I'm a Democrat, thought that the courts would just naturally be on our side. That's not true. That's not the way the system is set up. The justices are selected by the president who's democratically elected and confirmed by the Senate that's democratically elected. So the political part of it is hugely relevant there. You'll respect the Supreme Court when it makes decisions that you like, and you know what, the other side is exactly the same way right now. And so part of it is to say, we have to affect the composition of the Supreme Court by our exercise of our franchise. And then you have to get into the details and you have to ask yourself, am I ever open to seeing the other side in the Supreme Court as not correct, but as plausible? And sometimes it is possible and sometimes it isn't. With respect to, limiting or acting in a way that constrains Trump, it's very hard to constrain someone who's president of the United States in his second term, was twice impeached and not convicted, and against whom criminal charges were brought that the Supreme Court threw out, and frankly, they wouldn't have gone to trial even if the Supreme Court hadn't done that because there wasn't time. So Trump is uniquely unconstrained. It's a flaw in the structure of our system of democracy. It's a genuine flaw. And so what we're trying to do now is hold the line for the rest of his term. There is not another solution to that.
So we're going to have to do a speed round here because the lights are going to go out pretty soon. If you can ask a short question, that'd be great.
I'm not a lawyer. I'd like to introduce a concept which I think you will pick up. I would like to see a politician step up who is capable of speaking to every citizen in the country in front of any group in the country who says clearly, we are not safe, you are not safe, and these are the reasons why. And I think Attorney General will hit on some of it. Professor, it's a way to go with your argument, because then what is the alternative, which is the rule of law? But right now, in this country, over the next 4 years, none of us, including those who have sworn allegiance, are safe.
Thank you. Okay. Question here?
Picking up on Carol's last case that she mentioned, if we accept that people who don't have lawyers don't get equal justice when they're pitted against persons or corporations or governments that do have lawyers, what is society's duty? To what extent does society have a duty to provide them with attorneys?
In criminal cases?
No, in civil cases. We know what it is in criminal cases.
Okay, anybody want to address that?
You want to take a few more questions and then we'll just address them collectively, or do you think?
Sure. That sounds good. Okay. We'll write those down. Your question?
Excuse me, no short-term memory.
Oh, that's okay. That's good.
People have spoken about the Supreme Court not wanting to make a decision that the administration would ignore. I would posit that he's ignoring virtually, well, the law and orders in virtually everything he's done, including pushing the power, the concept, the understanding of the office to the point where he's blowing people out of the water because he can, because he thinks that's what dictators do. And he continues that. So much of what he does, even if it gets a ruling in the lower courts and the appellate courts,
If it goes on the shadow docket or it gets to the Supreme Court, they say, we're going to rule on this, but in the meantime, you can go ahead and do this, which gives the color, gives the thought that they are, in fact, behind what he is doing. Just briefly speaking, what can be done about that?
That's very logical. Yes, gotcha. We'll comment on that. Yes.
Hi, thanks for being here and for your time. My name's Adam. I'm a 3L at Maine Law. So I want to say thanks for you guys being here. But I just would like for you guys to maybe briefly speak about any perspective or advice you have for law students who are learning about the law now in this interesting and fun environment, and who are going to be practicing in this environment very soon. Thanks.
Great. Okay.
Since you're all lawyers, I thought that I would ask with respect to the rule of law that includes the rules of professional responsibility. How does Pam Bondi retain her license, let alone stay in office, particularly with respect to her testimony regarding her nomination and what she's saying now?
Okay.
You already asked the question.
So my question may be outside the scope of this event, but Professor, I really liked your explanation of the rule of law as both a system and as a way of life. And so my question really boils down to why? Why did we get here? Like a lot of people, the divide runs right through the middle of my family, through the middle of communities. How did a solid 35 to 42% of our fellow citizens so lose faith in the rule of law? Was it something about the system of the rule of law? I've got a lot of my own theories. I worked for years on the anti-torture movement, and I think when we started detaining people against international law and against the norms and morals of our society and convinced ourselves it was legal, and most Americans just shrugged their shoulders, I think some kind of serious like root canal level decay started to happen. But there may be other, I'd like to hear, why did this happen?
Thank you. Thank you. Okay.
Just a single word. Just a single word.
I think we should.
Germany. Rule of law, no rule of law. Rule of law.
A very quick question. The president seems to be toying with the idea of claiming extraordinary powers by invoking the Insurrection Act. And he also seems to be getting the go-ahead from the Supreme Court by have the theory of a unitary president that a court wouldn't have any right to question his judgment of invoking that. And I'm wondering your impression of where that would go if that ever happened.
Okay, great. Thank you. Okay, so the panel, pick any of those.
Pick anything you want.
I can answer the question about the law from the law student.
Wonderful.
So, you know, it's great to see you here tonight. As I said, I think lawyers have a unique role in this. In terms of sort of what you can do, I think one of the things that we can start thinking about as lawyers is providing civics education. The ABA had a task force on their study of democracy, and one of the things that they discovered is there's just a fundamental lack of education around civics education. So even just starting at that basic level. There are other things that you can do, like when it's time for voting, you can go out and volunteer your services to make sure that there's voter protection. You can go out and you know, contact your legislatures to talk about these issues and your feelings about these issues. And then when you actually become a lawyer, or even now, the Maine State Bar Association has a immigration defense section that was just newly formed to address some of these issues. So.
Yeah, that's very cool. Thank you for setting up that new section. A lot of lawyers in Maine are interested in now helping people that are being detained unlawfully. We didn't have that problem until this year, and the lawyers have really been volunteering. We set up a new section. There's trainings across the country, so there's a lot happening in Maine on that. It's great. Anybody else on the panel want to address some of the questions or topics?
I was also going to answer the law student's question. I'll leave all the rest to you, but yeah. I just wanted to say, I think one other thing that people can do is we cannot understand our rights if we don't know our rights. And so I think having really, really clear understanding, whether it's right to protest, free speech rights, you know, your rights surrounding immigration stops, We have on our website, so does ILAP, so do many organizations, really clear kind of bullet points on knowing your rights. I think educating yourselves about that, but also sharing that information. We have it in many languages, sharing it with anyone who you think that might help, because I think knowing those rights can be really critical when the crisis point comes. So I think just in a daily way, that's really important for anyone who's wondering what they can do in this time.
Great. Any other comments from the panel?
I'll offer become a defense attorney. We need defense attorneys. I was defense attorney for 10 years, and it's really good work, and we need public defenders and defense attorneys right now, so that's one thing you might want to think about. There is not, in terms of what's required, and look, hold the state accountable. This is from the Attorney General. The state does need to be held to the high standard that state should be held to, right? Like, the Constitution is a limitation on state power, so use that. We need defense attorneys to do that. In terms of who has rights to an attorney, look, it's a criminal defendant, it's somebody who maybe has a liberty interest that's being interfered with, so like a parent-child relationship that's being interfered with by the state, or if you're being involuntarily committed, there's a right to an attorney. Other than that, we have a great network of civil, whether it be, could be through the ACLU, or it could be through Pine Tree, it could be through ILAP. There are organizations that do pick up where the state does not provide counsel. The legislature has provided funding to support civil legal access, which is important. My office has provided about $500,000 a year for the last few years to make sure Pine Tree has legal access. So even though it's not required, there are civil legal service providers, as well as some grants that come in to the state that ensure that, for certain classes of people, you have access to civil legal services. So I wanted to address that question about what you might have access to for attorneys.
I'm going to give the final word to Professor Feldman, except I just want to say, if you like what you heard, Maine Lawyers for the Rule of Law, we're running a little deficit for this operation. So if you could consider making a donation at our website, that would be great. And then for speed answers, because I'm into speed, right to counsel in civil cases, Congress can create statutory fees, and so can the Maine legislature, so that a poor person against a rich person, they get the fees paid by the defendant if they win their case. That's been very effective, so that could be extended further. That's something that has worked really well. The Insurrection Act, one of the most conservative court of appeals in the country, ruled that you don't have to defer to the president, and that was a very piece of good news out there too. Very conservative judges appointed by Republicans. Once again, showing this is not a partisan issue. I don't think the press gave that much time or whatever, but it's amazingly important to know about that. And then the 42% and the rule of law, I would say, the rule of law has had problems. Like before, when I was born, women didn't have rights, black people didn't have rights, gay people didn't have rights. I mean, so the rule of law was kind of crappy in 1961. And so the rule of law needs to get better. That's one of the other problems. And when the rule of law, like if you can give unlimited campaign funds, et cetera, if we don't take care of the rule of law, then people lose faith. Then tyrants seem appealing. So I think that's a really good critique, that the rule of law, we need to keep boosting it all the time. And with that, I will turn it over to Professor Feldman.
Thank you. Thank you all for staying as late as you have, and thank you for amazing questions. You can think of some of the problems as ones that will automatically self-correct. The troops, the National Guard troops in different cities, that's going to eventually backfire and it's going to die down. Kevin Stitt, the incredibly conservative governor of Oklahoma, came out and said, this is a terrible idea, we would never agree to it in our state. That tells you something. So there are ideas like that. The emergency docket, also called the shadow docket, that's being overused now because it's a new toy, and the Supreme Court already realizes they're overusing it, and they will pull back on it. There's some things where the equilibrium is sufficient to reestablish them. The rule of law isn't like that. And the rule of law isn't like that because, as I mentioned, it's dependent, at least in part, on the pragmatic idea that people believe that it's doing some good for them. If people look at the overall picture of their world and they think that the whole system of everything that they see is rigged against them, then it is inevitable that people will lose faith in every aspect of those institutions, and the rule of law is an aspect of those institutions. And so, in the end, it will be very hard to recreate a sense of faith in institutions so long as people feel that the institutions are just not solving their problems. I don't think that the answer I don't think that the answer to that is a revolution. That's not my personal preference. I think revolutions sometimes work to create new trust, but almost all of the time they don't have that effect. What is needed is regular, serious, and committed reform from within the institutions and from within the broader state of society. And that's what insisting on the rule of law is all about. It is incremental, it is everyday work, it is painstaking, and it is 100% worth it. Thanks.
Thank you for watching. Please consider donating to the cause to further this work at mainruleoflaw.org.